Sorry about the technical difficulties, everybody. Can you all hear me? Nicolette, can you hear me? I heard somebody's dog barking.
Yep. Sorry, that's my dog. Great.
I was like, I hear somebody.
When you log in, there's a doorbell noise and he thinks that's the real doorbell.
Got it. Okay, let me unmute. Come on, you can work. I want to unmute Jeff. Hey, Nicolette, have you? Oh, there's Jerome. Okay.
If Jeff is having issues, he can always participate like he's participated in other meetings through Whova, and you can unmute him.
Okay. Hi, Jerome. Hi, Jeff. Oh, you're muted. Hold on. I'm trying to unmute you. Jerome, try to unmute yourself.
Mute. Yes. How's that?
That's better. I can hear you now. I can't hear Jerome. He's still muted.
Well, that was difficult.
I know. This is the first one of the whole large group meeting ones that we've done. And for some reason, Zoom didn't want to let me in initially. It was being obstinate.
There I am. Okay.
There you are. I'll say, I know you're there. Just can't hear you.
I lost my picture, so
Oh,
I'm ready now.
all right. Okay. We got in a few minutes late, but we do have people who have joined us. They're all currently muted for right now, but if you guys wanted to go ahead and start.
Okay. Introductions. I'm Jerome Mapp. I'm the plan director for the city of Caldwell. Been working on land use planning since 73, 74, and done a lot of stuff. I'll just leave it at that. Jeff.
Okay, I'm Jeff Pavlovich. I run my own consulting business called All Idaho Land Consulting. I help out cities, counties with whatever land use planning law issues they have. I'm not an attorney, but I do a lot of legal writing for cities and counties. And I, like Jerome has me by a few years, I've been doing this since 1976.
So we figure between two of us, we probably have close to 90 years of experience. That only means that we've been beat around about 90 years. What we want to do in this session is that, just give you background. Last year at the APA conference, I met a number of people who had just got into planning or recently became planning directors. And they were concerned that most of the sessions that were heard last year didn't pertain to the new planner. So I told them that I would see about a session being developed for new planners or planners who had questions, etc. So that's what we're all about. This is not a time for us to be lecturing. We want to be able to answer your questions that you may have, and we'll do our best to do that. But one thing we wanted to mention before we got started was that the story began in 1975. The legislature of 1975 created the Local Land Use Planning Act, which is the foundation of all that we do. And at that time, there was only about 13 elements or proposed chapters that the legislature stated that we had to put in a comprehensive plan. That number has increased to 17 at this time. So I also want to let you know that in a sense of resources, we don't have any handouts, but if there's something that I have, you can email me at jmap@thecityofcaldwell.org. And if I've got something that you could utilize, email me. Another source that many people don't use is Association of Idaho Cities. They just had a flyer. This came out this last week about P&Z training from Jerry Mason. Jerry Mason and I started the planning department with the city of Pocatello in 1974. So he's an attorney. He doesn't play one on TV. He's a live one. So he'd be a very good source of information. Also, the Association of Idaho Cities has zoning ordinances, guideline drafts, as well as subdivision ordinance drafts. And so if you're looking at updating your zoning or subdivision ordinance, contact the Association of Idaho Cities. As a city, you are automatically a member, and you can ask them any questions that you have anytime during the day. So those are the resources I want to share with you right at the beginning. Jeff, did you have anything?
I would just add that not only does the Association of Idaho Cities have a lot of information, so does the Attorney General's office. They deal more with like open meeting laws and the Regulatory Takings Act and those kind of things. But that office, through their website, has a lot of information, sort of more legalistics that's written by the Attorney General about a lot of things that we do. And one of the things that was brought up yesterday when the attorneys were talking was paying attention to your procedures. And I know those Attorney General's documents will help you through a lot, mostly for us, I think, through the open meetings law requirements. Because if you make a mistake procedurally, you're going to start over again, and it's expensive.
And I worked for the Association of Idaho Cities as the director of planning years ago. So I know what they have to offer. I'm assuming also for the county planners, contact Idaho Association of Counties. They can provide you information as well. So Jeff, you want to talk about before we go into questions, you want to share anything briefly regarding the Local Land Use Planning Act?
Well, I actually teach classes. I've been teaching classes in the Local Planning Act for over 20 years. And I can go on for about 2 hours about the Local Land Use Planning Act and how it works and how it doesn't work. So I'll just leave it with your email, Jerome, but if somebody has questions about that you want to forward on to me, please do, and I'll respond to those.
Okay, let's start off. Do we have any questions?
There are currently no questions that have been entered into the app. If anybody would like to ask a question, send me a message in the session. I can unmute you and we can go that route.
Okay, well, we'll just start off. And Jeff, chime in on this. The Local Land Use Planning Act require that every city and county should have a comprehensive plan. They did not say how to write it. All they said was what was needed in it. And so we talked about the 17 elements in the comprehensive plan. A number have been added periodically over the last 30 years, almost. The most recent dealt with airports and agriculture, which were usually in airports and transportation, agriculture and land use. But the legislature felt fit that those need to have their own chapters to really go in depth into the development of those sections of your comprehensive plan. One of the big issues or things that people forget to do is that really the requirements direct you to do an analysis of each of those chapters. And in that analysis, you should be reaching out to various agencies, organizations, not counting general citizens, to investigate, analyze each one of those chapters. The second piece of the puzzle is your zoning ordinance, that the comprehensive plan should be the guide within your ordinance, such as if you identify land uses in the land use section of your comprehensive plan, those land use sections should be zoning classifications within your zoning ordinance. And then the third leg of that stool is your subdivision ordinance. And the subdivision ordinance guides you in how you divide property within your city limits. Okay, we're still hunting for questions. And
John, let me pose a question to the audience, and maybe somebody will, hopefully somebody's listening. What in the Local Land Use Planning Act, what is the one and only duty of a planning commission? Okay, maybe nobody's out there, Jerome.
No,
It's just us.
we have people on here. I'm trying to see if I can just unmute everyone so that if they have. But I haven't had any questions in the session Q&A or in the chat.
okay,
Well, I'll answer that question, and it's in the state law under section 676508, and it says it shall be the duty of the Planning and Zoning Commission to write a comprehensive plan, and then do anything else that the governing body, which would be your city council or board of county commissioners, whatever else they give to them. But unfortunately, Idaho's Local Land Use Planning Act is very confusing further on, as Jerome said, you have to have a zoning ordinance. But first it says the only thing a planning commission does is a comprehensive plan. So I guess my chiming in here is Jerome's correct about all the things, and you have to analyze. It says you have to analyze all of those elements. And then you go on from there. So anyway, I just wondered if anybody knew that little, I think it's a glitch myself, that it starts out with, that's the sole duty of the planning commission. Unless the board of county commissioners or city council gives them other duties, which obviously is very common and almost universal.
And those duties should be written in your city code of what the functions. What I found out over the years is that planning and zoning commissions don't know what their duties are. That staff hasn't given them the section of the city or the county code that outlines their duties. In the same breath, the planning and zoning director has duties as well. And those should be also written in your city code. As I look at, it says legislative authority regarding the Land Use Planning Act. As I said, requires all cities and counties to exercise the responsibilities identified in the act. The law allows the city council may delegate some responsibilities to the Planning and Zoning Commission, except the adoptions of ordinances, comprehensive plan maps, changes, comprehensive plan amendments, annexations, zone requests, and the approval of final plats. That's why planning and zoning commissions make recommendations to the city council, and their authority to make final decisions are on special use permits or conditional use permits if the council gives them the authority to do so. In smaller communities, the Planning and Zoning Commission is the city council, where they ultimately make all the decisions regarding land use within those cities or counties.
Jerome, is it fairly typical for most jurisdictions, sorry about the barking dog. Is it fairly typical for most jurisdictions to give that authority to the P&Z Commission with regards to conditional use or special use permits?
From my experience, it's been based upon size of the community.
I agree. I would say larger communities, which obviously I was the Development Services Director for Ada County. And so I've worked in big jurisdictions, and I would agree that in the larger jurisdictions, they delegate that authority. In smaller jurisdictions, the Planning Commission, even on special use permits, makes a recommendation to the city council or the board. It makes it a very lengthy and cumbersome process. But that is typically what is done.
Thank you.
Let's, somebody have something else?
I tried to unmute everybody. Some people, obviously, you have the choice to not be unmuted. But I did try to unmute everyone. If you do have a question for our speakers, this is a great opportunity to pick their brains of anything that you have.
And thank you, Christy. I think that Jerome and I really would like to answer questions or have you asked that we talk about something about a planning department or the planning commission, rather than us try and lecture, if I might, Jerome, I'm going to jump in and ask a question again. How many people are aware that in 2012, the legislature said that if you have a special use permit, you can grant the what are listed as a variance in the statute just because you want to. You don't have to make the findings of a variance. They just willy-nilly made that change because of a lawsuit over in the Teton Valley over a height of a cement plant operation. And so now, it used to be if you wanted that kind of, I guess, variance, to use that term, you had to go through the very hard rigors of a variance application. And now they've changed that and they said, you can just grant it. You don't have to make any findings or anything. You can just grant it because it's part of a special use permit. On the other hand, if you want a variance that's not a special use permit, you have to go up against the variance problem.
And I'm sure you know that a variance has to deal with a hardship that you did not create on your own. And it can't be a financial hardship. There's 6 questions, I believe it's 6 questions that has to be answered in the affirmative for a variance to be issued. And if somebody wants to know those conditions, I could look that up for you pretty quickly.
Well, they're in 67, 65, 16. If anybody wants to look up that statute, and it's, they're hard to come by. From a legal basis, it can't be a right or special privilege. It can't be an undue hardship because of, it has to be a hardship because of the site or the site characteristics, not because you want it, or in a case that I had in another state, same laws, these people bought a set of house plans, and then they bought a lot, and the house plans didn't fit on the lot. So they asked for a variance, and they made it the city's problem.
And hardship.
Yeah, it's a self-imposed hardship. And there, my point is that in 2012, because of this Supreme Court case in Idaho, now if you go have a special use permit, you don't have to try and justify anything. You just ask for it.
I have a question about variances here. I'll turn my video on so that you're not talking to a blank screen. When I was at the county, obviously now under my new role, I don't really deal with variances all that much, but when I worked for the county, we were seeing a plethora of people submitting variance applications. And as you say, there's specific criteria they have to meet. Special right or privilege, site characteristics that are causing the need for the variance, as well as other things. We would routinely get applications that did not meet those criteria, obviously, so staff would generally recommend denial, and then the elected officials would routinely grant them. So how do you tell the story for elected officials so that, because does that create an issue with precedence? Because
No.
I know we make that argument that every application and every site is individual in and of itself, but it's still, we would have elected officials would say, well, we just granted one a week ago for the same reason, so how can we not grant it now? Is that an education issue with our elected officials, or?
I will answer that in my, we don't even talk about decades, years of experience, do we, Jerome? We talk about decades.
You're right.
That, yes, it's education, and the elected officials routinely, as you say, overturn the planning commission in this case, because they want to, or it's their constituents, and the way they learn is by getting sued. because the staff doesn't get sued, the planning commission doesn't get sued, the elected official gets sued, and they control the purse and they have to pay the price for it. And that's how they learn. And that's my experience is it's absolutely education, but the way they learn is when they have to write a check to somebody for violating the law.
Yeah. What's the impetus for a lawsuit, though? Oh.
Yeah.
As a former staff person with the city of Boise, as well as a council member there, I would just add is as a staff person, all you can do with the P&Z and city council is give them the facts.
Right.
The P&Z definitely need to follow the guidelines under state law of what identifies as a hardship or any application that comes before them. The P&Z should be following what the code says, the local ordinance as well as the state code. When you get to the elected officials, they don't necessarily have a pass, but they have the opportunity to make a decision on why they do what they do. The key for the council that I could speak more understanding to is if they go opposite of what maybe the state code says, they better have a good reason why they did it. And that should be part of their findings of fact of why they made a certain decision. I've seen council just say, we're going to approve this. And they do one or two things. They ask the staff to develop a reason based upon their discussion during the hearing, or they provide no explanation of why they do it. That goes back to what Jeff was saying, is that if something does go to court, the court at least I've never known them actually reverse the decision. They send it back to the elected body or the P&Z commission to start all over again and get it straight because there's something in the process that was incorrect. You know, we talk about P&Z and that's a new ruling on me, Jeff. I had not heard that ruling. But over the years, for P&Z commissions, the legislature or the courts have added new responsibilities or requirements to the Planning and Zoning Commission. One of those, which I had done for 20 plus years, is to, actually I was a hearing examiner for Caldwell for 21 years before I became the director. And when I was a hearing examiner, my first hearing, this would have been in the late 90s, I would go out to the site for somewhere between, I think it was about 1990 or 89. There was a court case regarding a hearing where where a P&Z commissioner went out to the wrong site. And this went through the courts, and the court said, basically, the Planning and Zoning Commission is like a court. That is, no one can go out on the site unless everybody goes out on the site. Nobody can hear any testimony unless everybody hears the testimony at the same time as a court. Which meant that a P&Z commissioner cannot go out and look at a site that's on their agenda. That's a no-no. All the information has to be laid out at the public hearing so both parties can hear the information at the same time and can rebut it at the public hearing. So that's been a change in the last 20 years. That wasn't the first, 15?
If there's no other questions, maybe we'll just change topics, Jerome, that you and I know have talked about.
Take it away, Jeff.
Can't.
Can you guys hear me okay?
No.
You're choppy a little bit, Elizabeth, but not bad. You can always go ahead and try it, and
Okay,
if not, you
sorry.
can type it in and I can relay it for you.
Okay, go ahead.
Okay, so I missed the first. Okay, I missed the first part. I missed part of it, so I don't know if you already talked about this, but when I started working as a city planner up in Hayden, I kind of struggled with, like, in the beginning with public hearings and how the public would respond to what the applicant was proposing. They would just be so angry, and I just didn't know, are there ways to kind of navigate that when that happens?
Christy, can you interpret that? Sorry.
Yeah, she said when she was first getting into planning at the when an applicant, and correct me if I'm wrong, Elizabeth, the applicant would be angry, I think, about maybe conditions that would be required, and she was questioning how to navigate that, how to handle, I think just overall in general, how to handle applicants. And like when I was at Ada County, we had a lot of people that would come in who didn't understand the application process itself. And I dealt with that a lot as well. People would be very angry that they even had to go through a process to submit an application, the whole, this is my property, I can do what I want kind of thing.
Right.
Oh, she wrote angry public response, how to handle the public. So it can go into a whole vacuum of that.
I'll chime in here, that not only for me as a planning director, my responsibility is to educate the planning commission and the governing body, but also to educate the applicant before they come in of what the rules are, and what our ordinances say and what our rules are, and to some extent the typical kinds of conditions that we would be imposing on that kind of application before they even start, so that they know. Because our job, I've been a member of AICP since 1988, and so is to not only educate planning commission elected body, but the public on what the rules are and what the process is. So I don't want somebody coming in saying, well, no one, i.e. the staff, no one told me I might be faced with these kinds of issues unless they come up during the public hearing, which of course no one knows until the public hearing starts. Jerome?
That's the nature of our profession. And I agree with Jeff is that, and it depends on what part of the state you're in, where it might be a little more hostile than other places. I'm just being frank. The challenge is when you have an angry customer or a client that comes in, that means that's when you have to, as they said, if they go low, you have to go high. You have to be patient with that individual. And you might have to walk them through the process so they understand. You could tell them, I understand your frustration, but this is what the code says. And let me just walk through the ordinance and kind of show you why this is happening. And the more they get angry, the more kinder you have to be. And a lot of times it's because of the shock that they can't do whatever they want to do with their property. Because what they do affects their neighbor, and their neighbor may not be the person next to them, but as a neighbor in their community. That this has been something that's gone through the process with your elected officials. My responsibility is to enforce what they passed. If there's concern about the language in the ordinance, you could speak to my planning director, or you could speak, to an elected official. But my responsibility is to follow the law, and that's what I'm trying to do.
I might add to that, Jerome, if you look at the statute under 676512, subsection, I call it little d, I'm sorry for not capitals and stuff, it says, upon granting of a special use permit, conditions may be attached, and it lists out 8 general areas that can be addressed in those conditions. And again, I as an AICP member, I think part of my job, and Jerome said the same thing, is to educate those applicants on what that process is and what they might face at the Planning Commission. But I would add, at the Planning Commission, if people bring up other things from the audience, I think our role as a staff is to say, when the public hearing's closed, is to say, okay, John Doe said these things, but they're not part of the law. And so we don't need to address those, even though that person may think they're honestly part of his issue. But our job is to abide by the law of state of Idaho and whatever local jurisdiction you work for. And I think it's pretty clearly spelled out in those, that subsection D in 12. And then subsection E is even more onerous, that says we can require studies. And those may come up, before or after, or excuse me, before the public hearing or during the public hearing. But again, I think it's a matter of education. And some of those applicants aren't going to listen. I've worked in rural communities. I used to work in Island Park, which is obviously a big resort area, so you get a lot of people who own property who are from a different state, and they have no idea, nor do they care what the laws are in Idaho. They simply either want what they want or don't want what their neighbors want. And that becomes a much harder problem when people are from literally all over the world owning property and want to testify at a hearing, when they just show up at the hearing but don't know what the rules are.
Yeah, we have to follow up in the chat. I don't know why it's a weird thing like that sometimes.
Jeff, I'm sorry.
No, I was just going to tell you that we had some additional comments in the chat talking about this subject, where there's been frustration with not only the public not understanding processes, which I don't have all of the years you guys have in, but I do have like 13.
Well, you're just
lucky 13 or I know, lucky 13 or 14 in there. That and I would probably agree with both of you guys. I would try to just educate them to say, yeah, you want to do this with your property, but we have these laws to help protect, so that your neighbor can't go in and put a strip club right next door to you. There's reasons for why we have those. But the discussion on here is a lot of times that it's members of the public that are upset about an application, or there's feuding property owners where what they're upset about has absolutely nothing to do with the application, but that tends to bleed into the application via the public hearing or letters that are sent. I dealt a lot with that, and that's one of the comments was, where is it? Oh, where they had one situation where the neighbors were putting nails under the applicant's cars, among other things. Applicant ended up getting the police involved in cameras. It was so draining, and that, as a planner, it can be very draining.
One of the challenges that they don't, I went to school in architecture and sociology, so I didn't go to planning school. But I found that in the planning business, I use my sociology degree a lot more. And when you're dealing with people, you do have challenges. I want to back up a little bit. There's something when Jeff was talking about Planning and Zoning Commission. I would like to know how many people provide training to their P&Z commission annually. Land use training about what a comp plan is, what a zoning norm is, what's a subdivision, basic criteria. Or do you even give them an opportunity to ask questions about what may have happened at a public hearing a month ago, 12 months ago? Do you provide any kind of training to your P&Z commission? Does anybody?
Well, I'll chime in since I'm one of the speakers. I would provide that as often as I could. I tried to do it 3 times a year. Depends on where you're located. If, when I worked in Ada County during the boom years, we really didn't have time to do that because we were having 4 to 6 hearings a month. And it just logistically didn't work. But I have tried to educate them from everything from what the local land use planning act is and how to make a meeting work and how to run a public hearing, how to make findings, just as best I can so that they're educated when it comes to what they're doing on a day-to-day basis or a month-to-month basis. Now, one thing I would chime in with these hostile neighbors, males are okay. It's when they bring loaded shotguns and put them on the podium that gets a little scary. When things get hot, when I see a hostile item coming up, I take time to go through in my introduction, my presentation, to line out what the laws are and what the rules are, and that people have to testify as to, and when I'm talking about people testify, I'm talking about those for and against, not the applicant, of why they think the application meets the code or doesn't meet the code. Not because where am I going to walk my dog is not my issue as a planning commission. I've had that happen. I've had people get mad because they rode their horses on somebody else's property and they were going to develop it into a housing tract and they didn't have anywhere to ride their horses anymore. It's like, well, you need to go, and I'm going to jump forward in it. When you get to writing those findings with the planning commission, and I think Jerome, I'm going to go back to where you were talking about the elected body saying, well, you draft the findings. I would sit down with the planning commission and say, okay, here's what we heard from these people, in a list, and have the planning commission say, or tell them, this is irrelevant, the walk my dog issue, or yes, this is part of our code and you need to decide whether you agree or disagree. And that I found tends to unfortunately lengthen the process out, but also it's very clear of what the rules are and what we're there to hear and not hear. So when somebody brings in I'm not even sure it was a survey map, their map of what they thought they owned back in the 40s, I don't really care anymore what that is.
So the findings of fact is the information that was accumulated during the public hearing. And the conclusion of law are those legal aspects that you make your decision on. And that will carry through from the P&Z hearing to the city council and to the courts if it goes that far. So what Jeff is saying or at least want to add to what Jess was saying, is you want to have a clean record during that process. And to get that clean record, I'll go back to what I was saying earlier. The P&Z needs to be educated to their responsibilities and the process. When I was a design review analyst for the city of Boise, and I had new commissioners, we had a design review manual, some other documents. I would meet with them, I would give them that information, and I would say, I'll see you next Tuesday. That's what happens, and somebody correct me if I'm wrong, which a lot of P&Z commissions, is that they want to come to a meeting or they want to be a part of the process, but they don't know the details of that process. And as a staff person or a director, you're responsible to do that. Also, your staff needs to have an understanding of what their responsibilities as a member of the planning and zoning staff. You know, this is not, let's make a deal. You know, you don't make deals with applicants in regarding to their development. What's required in the code is what you have to provide direction to. And in those areas that may be gray, there could be some discussions in regarding what the possibilities are, but that may have to be decided by bodies above you in the office, unless your code allows you or the city council allows you to make those kind of decisions. But I can't emphasize the issue of education for the public, for yourself, and for the P&Z and City Council. I served as the hearing examiner for Caldwell for 21 years and 8 years with Canyon County. And I say that to ask the question, has any cities thought about hiring a professional hearing examiner to conduct public hearings in their community? Well, there are some advantages and disadvantages. One of the advantages is that a hearing examiner may not be partial to certain individuals or development. They may be able to take a more objective view. From my experience, the hearing examiner can go through more hearings. They can be, if they're based upon their professional background, they can get through a lot of the minutia that sometimes comes up in a public hearing. That is some of the things that Jeff was talking about, things that may not be relevant to the public hearing. They could probably easily say, well, that's something I have no jurisdiction over. Probably better than a commission. The negative about a hearing examiner is that it may not be somebody local in the community. And some people might resent that. That's the only one I could come up with. So from my experience, I was responsible for the hearing examiner in Pocatello back in the late 70s. And I was his direct contact, and that worked well also. You can have planning and zoning commissions and hearing examiners in the same jurisdiction at the same time, especially if you have a lot of public hearings, definitely during a boom period. If you have the staff, it allows you to get through more staff reports and more items before your hearing body. Let's see. Oh, here's something I think is really important. Do you have definitions in your ordinance? Are the definitions the same in your zoning ordinance, your subdivision ordinance, or your comp plan? Or are they different in each one of those documents?
I would add to that, Jerome, and everybody else. You're absolutely correct, and I agree that your comprehensive plan and your implementing ordinances, zoning and subdivision, need to have the same definitions. But the more you can define or provide definitions, and I'm speaking going to court, judges like definitions because they have, and I'm going to say also decision makers, they have a term in their mind and a definition of it, but that might not be what your ordinance says. And if it's open to interpretation, you potentially have a problem. And your last thing on that is, the more definitions you should be defining everything in your ordinances that you can. I mean, it's almost to a point of being somewhat ridiculous about it. And also, judges like diagrams, pictures. So if you can add pictures to your definitions and say, here's a definition, here's a picture of it, and I think everybody uses this nowadays, but we go through and we define what front lots are and side lots are and all those different, but if you can put a picture of those yards and define and show them, everybody then knows what they are in a picture rather than trying to interpret some quasi-legal language. That's really helpful in the process.
I have a question. Just to follow up on the definitions conversation. So it's a two-parter. For definitions, so you would say that a more clearly, like, language that says, for example, or these things, but not limited to, would be a bad thing to put in a definition?
No, I would not.
That would be a good thing.
That would be a good
To
thing.
leave them more vague.
Well, that can be vague, but for example, in the statute under section 16 for variances, it says something to the effect of including the following things and other things like them. And I think everybody understands that, although the Supreme Court has never been challenged with interpreting, is that an inclusive list or a suggestive list? And your list of including but not limited to, I would say is a suggestive list. But it's also known legal language in the courts, what that means. If you go through and you add all those things like for a variance, I think it's pretty clear in the Idaho statutes and in other state statutes, it's, they're saying they're bulk standards. Now, if you can go find and define bulk standards, do it. Don't just say, well, a variance definition says bulk standards and we know what they are, but no one else really does, or the common person doesn't. And a judge may have his own view on it. So.
The second part of the question is, I've worked for a jurisdiction or two that when they were working on updating their ordinance and were looking to expand the definitions to make it more clear, there was pushback from legal that reviewed drafts to include as many. They wanted, how do you navigate that when you're, because generally when you're doing an ordinance, it's a lot of times it's not just your department. You have to have legal review it to make sure you're not violating codes and things like that. So how do you navigate that when you're trying to be?
I would ask that legal counsel, what's his issue with, what are his issues with those definitions that he's wanting to be shortened up? I mean,
Or removed.
Or removed.
Yeah, that was the
say
problem we were running into, is they were
Yeah.
wanting them removed. It was too many.
Okay. And for example, years ago, you don't remember how many, it wasn't that many years ago, in the statute, no one knew who could appeal under the statute. And so we had them put in, whether you like it or not, they defined what an affected person is. So everybody now knows, again, whether you like it or not is not the point, but we know now that what an affected person is in Idaho for a land use appeal. And before we didn't. And so, I mean, those kind of things to me are much better. And there may be some things that you don't have to define. I've certainly worked in places where the attorneys have said, well, that's already defined in another part of the statute that we don't deal with. And you can go and find it there. And so that certainly happened to me. But again, I was trying to make my own definition, but they were saying it's already defined elsewhere in the statute that we just didn't deal with, and that was helpful. So I'm going to go back and say it's a matter of education from both the attorney side as to why they don't want to define something, and again, honest and open discussion from a planning standpoint of why you think you do. Ultimately, that means you got to defend your elected body in court.
The truth is, a lot of attorneys are not land use attorneys.
Yeah.
And that's where the problems start. And I've dealt with, all types, but I've even had an attorney tell a county that you didn't even need definitions. And so I think that if there's something in your ordinance that's confusing to a lot of people, you should define it.
Christy, I'll give you just an example that came to my head. And I don't even know what the statute numbers are, but they have to do with roads and streets in Idaho. And they define what a street, a road, an alley, and all those things are. And there's no reason you can't just either reference those or extract those out of that other statute and put it in your own. But you certainly don't want to get crossways with it and have different ones.
Right. We talked about planning and zoning commissions. One of the things in the sense of developing staff reports, I'd like to take some time to talk about that. What is the purpose of a staff report? Education and information to identify what state code or city code says about an applicant who wants to develop their property. And so in that staff report, there's a lot of base information that you have to get to the commission. Since they can't go out on the site, you're responsible to describe and identify pretty much everything. They need to know what type of land uses are, not only what the land use is, the property, but what the land use and the zone is on all property around the proposed applicant's development. They also need to know what the code says. You know, why are they here? Special use permit or conditional use permit? What are the parameters, concerns? Subdivision, a plat, a variance? You need to provide them a background of the application, the general facts, if you will. Also, you have to look at the professionals in your office, that is, city offices. If it may affect the airport, you need to get some comments from the airport manager. If it's dealing with streets, which most developments do, you have to have your city engineer. If it's near a park, you need to have somebody from the Parks Department. So no matter where the development is, you know, it's going to associate itself with some local government that needs to be contacted. It may be, if your city doesn't have water, it's a water district, you got to contact them. Fire department. Like I said, all those various agencies. Engineering is probably one of the big ones because they're going to talk about infrastructure in your community and how it's going to be affected. It's amazing how sometimes those individuals are not contacted. You're going to have your testimony by all parties, those in favor and opposition and neutral. You have to give them a lot of time to make their presentation. But remember, is that people will talk as long as you give them to talk. So for instance, if you give the applicant 10 minutes, those in favor 3 and those in opposition 3, that's a lot of time if they utilize that time to focus on the application. Not spending a couple of minutes telling you what Aunt Sadie said last night at dinner about the application. If you notice in public hearings how people sometimes wander in their conversation, that they have additional time, so they start repeating themselves. So it's important during that public hearing process that the commission provides some guidelines of how the public hearing will be held. Don't forget your comprehensive plan and do an analysis of your comprehensive plan as relates to the proposed development. You can identify how it complies to the comp plan as well as how it doesn't comply to the comp plan. And then you finalize that with your findings of facts and conclusion of law, and then the necessary conditions that need to be placed on the application. Remind your P&Z that you have other responsibilities than trying to monitor a condition that they placed on an application, in my terms, for convenience, such as you can have any cars sitting in your property between 9 and 5. And the only way that you can know if that's happening is either one of your neighbors, their neighbors calls and tells you, or you're going to go out monitoring that person's home from 9 to 5. What I've always said is that you only place conditions that can be enforced, not conditions that make people feel good. So remember,
Jerome, maybe we're sort of getting short on time, unless there's any questions out there. Anybody has comments?
I don't have any questions come through the chat, but if anybody that's on here wants to unmute themselves and ask a question, please feel free to do so.
I just want to touch on a few last things before our time's up. So if you have any questions right now, stop me if you do. Jerome talked about, what the staff report is, but let me just bring up the issue of, what does your application form say? What does it require? Does it say the same thing that's in your ordinance? For example, if your ordinance says you have to supply this report as part of the application material, does your application actually say that? And if it doesn't, then they need to be made the same, one way or the other. I'm not here to tell you the report, whatever that might hypothetically should be, a part of the application, or you could make it after the fact a condition of approval. The issue here, and again, I'm sort of more of the legal person around here. There was a case in 1990, Johnson versus City of Homedale, where the code and the application said, okay, applicant, you've got to submit these reports, these narratives, and this information up front with the application. The staff, the planning commission, the city council said, no, you can do it after the fact. Well, the neighbor sued and said, no, I need to see those things up front because your application says so. And he won. The city lost. The city had to pay money. Again, the elected officials, hold the purse strings. So my point is, look at your code and see what it says as far as what things need to be submitted when, and make sure your application says the same thing, and then follow it. The other thing I want to bring up is, and sort of somewhat of this COVID-19 thing, is how do you deal with a public hearing when, like we're doing right now, there are certainly large geographic parts of this state where there is no internet access, or people don't have access to this kind of equipment. It's not available. So what do you do with a public hearing, a public notice that says you can come to the hearing, but you can't, there's no hearing, it's all done electronically, and that person or that group of people don't have access to that? I don't have an answer for that one.
Jerry Mason is doing a workshop on that, right? I think it's tomorrow.
I think it's tomorrow morning too. Yeah. I would encourage everybody to listen to that. I unfortunately will be out of state at that point. But my point is, with this COVID stuff going on, and even before, do you really encourage public participation? And how do you do that? For example, another state I worked in, the largest city, but it's kind of like the state of Idaho, where you have something like Boise, which is the big city in the state. In this case, it was in the county, but the legal newspaper from back in the 1800s was some little newspaper that no one ever read, no one even know how to get a hold of, but they put the public hearing notices in that paper because it was the legal newspaper of that county. But yet they didn't put it in the big paper because they didn't want to go through all the hassle of the public hearing. They just wanted to avoid it. And they went to court over that and they lost, but that was a different state and a long time ago. my point is, look at your public participation process, and is it difficult, confusing? I saw one, I won't name where it is, one city in this state recently, where if you, not the applicant, but the public hearing notice said if you're for or against it, remember the public, you have to have a sworn affidavit signed and notarized for you to be able to testify. But the applicant didn't have to do that. And so that was very cumbersome. I've never heard of anybody doing that at a public hearing outside of court, mind you. Okay, this is a local land use planning issue. And it seems to me that community made it as difficult as possible, cumbersome to participate. And I don't think that's what public hearings are meant to do. They're meant.
What was the purpose of the requirement for an affidavit?
I have no idea. I just know it's there. I just know it's there. I looked at it and I'm like, that's unbelievable.
You have to message me and let me know where that's at, because now I'm curious.
Okay, I better not say public where it is, but I will.
Okay.
And let's see. Let me just jump. The other thing I want to talk about, and I've seen this in smaller communities be a problem in Idaho and in other states, but we'll talk about Idaho, is the organization of your planning commission. The statute says you've got to have organizational papers, or I'll just call them bylaws. And you've got to have your meetings open to the public. And I've seen planning commissions go into executive session, which they can't, and talk about things that I wasn't involved in. And also, this is the biggest problem I have, is the statute says you've got to notify the applicant of your decision in a timely manner, something to that effect. It doesn't ever say how long you have. But I've been working with a few cities over in eastern Idaho where they refuse to give you a written decision. They wait for the minutes to come out, which in this case can be 2 to 3 months. And of course, then you've lost your right to appeal to court. And so for those smaller communities or new planning directors, make sure that your process, this is a process issue, that your process follows the statute. And little things like, do you have in your ordinance what that reasonable time is? Is it 10 days? Is it 15 days? I'm not here to tell you what it should be, but it's got to be a reasonable time. I think most people use for 10 or 15 days. But again, over a couple of places I've been working against, basically, they've never notified us, and we're the applicant. So we don't really know what the written decision is, I guess, until the minutes come out. Anyway, those are just the last couple of things I wanted to bring up of looking at your ordinance to make sure your process is correct. Because that's the first thing a judge looks at is your process correct and did you follow it? Not is the substance, that's the second question. He or she's gonna look at the process, and then if you didn't follow it, he's gonna kick it right back and you're gonna do it again. And that's no good for anybody.
Yep. Just adding a couple of more pieces for the next couple of minutes. For cities, we need to use the tools the legislature has given us. Development agreements work well if you have the staff that can keep up with that process. An attorney that can help you write those development agreements. Development agreement is basically additional conditions above what may be required at a public hearing to make sure that the proposal that has been brought forth is going to be built as stated by the developer. And they'll go into more details about street improvements, landscaping, design of structures. We're talking about major detail, but it can still save your community a lot of headaches in regards to what they said at the public hearing and what you see in the ground or on the ground 2 years later. It could be actually two different things. Another tool is the plan unit development. That's a very good tool in regards to land use planning for housing of all sorts, as well as subdivisions and commercial industrial development. Another good tool as well. We're getting close to the end. Are there any questions that has arisen during this presentation? It wasn't supposed to be a lecture, but we did what you want us to do.
Jerome, I don't have any questions in the chat or in the Q&A for you guys, other than a comment that that Jeff's conversation about the affidavit was nuts.
I agree. I'm not defending it.
I had myself on mute, but when you said that, I said that's great. That's cuckoo for Cocoa Puffs. So I agree. Well, thank you, gentlemen. Is there anything you would like to add at the end here?
I would just remind you that your associations, Association of Idaho Cities, Idaho Association of Counties, can also be a resource when you have questions. As I said, AIC, I've worked for them. I've worked with them for over 20 years. A valuable resource for you cities. Don't forget them. Call them up.
As well as your local Idaho APA chapters.
Of course. and that's a really good point that
Yeah.
I forgot, is that one thing we've been doing for 30 years with IPA and APA Idaho is sharing information.
Mhm.
And so the idea that you've got a question, you've got a list of participants in this conference, and I'm sure any of them would answer any question if they know the answer. So call them up. If we were live, we will be passing cards around. But you've got folks who live not too far from you. But also during this age of Zoom and cell phones, you can call anybody anytime. And so you should do that.
And there's as part of the Whova app, I don't know if you guys have been playing around on it much, but within each session, there's the Q&A, there's a chat, but then there's also a tab that's called Community. And that is where there's people are organizing virtual meetups after the conference, or if there's specific topics that, like there's an ag chat, there's ethics after party, there's different things on here. So I would encourage everybody as well to go check out the community page. And that's going to be a great place for contacts as well. You can meet up with people if you want to create a new topic that you've got concerns over, or not even concerns, something that you want to know more about. That's another place that you can do it. But yes, as Jerome said, please reach out.
I would just add also, and Kristen, I don't know if you or Jerome mentioned it, the Idaho APA chapter people, and particularly those like myself who are a member of AICP, are here to help you out. That's part of our licensing requirement. I'm not saying we're here to write your zoning ordinance for you, but as far as education, kind of like we're talking today, most, if not all of us do it, but a lot of us are available to help your community out in understanding how this all works. So make yourself available, avail yourself of the state chapter people.
Thanks, Christy.
Oh, sorry, I was trying to unmute and it wasn't wanting to unmute me for some reason.
Oh,
Yes, thank you guys. And Elizabeth
you, everyone.
Allen wanted to remind everybody that under that community tab, there is an emerging planner check-in under the community topics.
Okay.
So if anybody's interested, jump over there as well. All right. Thanks,
Great.
everybody. Have a wonderful
everyone.
afternoon. And we'll
Bye-bye.
see some of you tomorrow. Bye.
Bye-bye.